consider that and say to their government, and say to this government, let's do the right thing here. Let's get the consultation right. Well, the former Solicitor General in these benches, I'm sure he knows that when something like this is being done, it is not right. And I would encourage colleagues to press their government on this issue. In paragraph 60 of this report, it says on the 21-day breach that this House may wish to press the Secretary of State or press the Minister for further justification on why the 21-day convention was breached. We ask the NIO to consider carefully any possible future breaches of this convention. Why, Secretary of State, have you breached the 21-day rule? Under no obligation to do that. You've breached it. There's lawyers in these benches. I'm sure they would want to know why the Secretary of State has done it. What's the compelling reason, Secretary of State, for breaching the 21-day order? It just appears absurd to me why this has happened. It would have been helpful if the Northern Ireland office liaised with the Department of Education to ensure that more information was available, was how this report concluded. Madam Chair, what do these regulations do? Very, very briefly, Madam Chair. They will force all schools, regardless of their ethos, their religious background, their moral views, the views of the head teachers, board of governors, etc., to teach children between the age of 11 and 16 years of age that they have the right to abortion. That's the law. That's what we teach them to do. And how to obtain one. And how to obtain an abortion without their parents' consent. That's what it will do. It will remove parental responsibilities in this. It will prohibit further the presentation of any opinion opposed to abortion. And the explanatory note, which is in front of us tonight, states that schools must not, and I quote, advocate or promote any particular opinion on sexual and reproductive health and rights in accordance with the recommendations in the report of the inquiry concerning the United Kingdom of Great Britain and Northern Ireland under Article 8 of the optional protocol to the Convention of the Elimination of All Forms of Discrimination Against Women, in other words, the CEDAW report. Forcing religious discrimination, forcing schools to promote and facilitate abortion is not a neutral or value-free position. The government is forcing schools to take on a position that is not normally theirs. And these regulations, therefore, are aimed at exclusively at suppressing the expression of a particular viewpoint. And it threatens the conscience and the rights of teachers, of school boards of governors. It is against Article 9 of the Convention of Human Rights. It also contravenes the terms of 76 of the Northern Ireland Act 1998, which prohibits public authorities, such as the Department of Education, from discrimination based on religious belief and political opinion. Secretary of State, if you want to end up, if the government wants to end up in court, they will end up in court by pursuing this evening. And I would encourage them to pull back from it and to get this right. Section 75 of the Northern Ireland Act, on the other hand, recognises the particular religious character of the role played by boards of governors in Northern Ireland when it lists them among the institutions exempt from the statutory duty to have due regard for the need to promote equality between religious beliefs and political opinions. So we are asking, and I'm asking the Secretary of State, to keep the law, to make good law, to make law consistent with what was laid down in 1998, and not to drive that law in the opposite direction. The regulations have been condemned by both sides of the community in Northern Ireland, and that point has been made well this evening. Secretary of State, can I just say that these regulations seek to impose an ideologically based view on abortion on schools in Northern Ireland, contrary to the legal protections against religious discrimination. They are also being rushed through without consultation and in breach of parliamentary convention. This is bad law. I would ask the Secretary of State to pull back from this tonight and to make good law.
Thank you, Madam Farage. We have heard a wide range of strongly held personal views and varied contributions on all aspects of regulations, these regulations from members in the committee representing all parts of the House. I'd just answer some of the questions that have been raised. Just to clarify completely for the honourable gentleman from North Antrim, my officials undertook an equality screening under Section 75 and considered Section 76 There is no impact on discriminatory impact on religious groups. Providing such information in the curriculum will not affect the ability of parents to provide advice and guidance to their children in keeping with their religious views. The member for East Antrim asked a couple of questions that I'll pick up right at the very beginning, and I'll re-emphasise a bit later on in my words. He mentioned the court case from the Court of Appeal judgment in relation to the Society for the Protection of the Unborn Child. I'm pleased that the Court of Appeal judgment has recognised that the UK government has acted lawfully. The government is committed to ensuring that women and girls are able to access abortion services to which they have a right and which are available in all other parts of the United Kingdom.
Do you win?
I will happily give way to the Honourable Gentleman. Right.
The point of the court case and the comments of the judge were that education was not covered in the consultation which there was on abortion, but there would be an opportunity for that to be covered when the Secretary of State brought forward regulations. He did not consult with anyone, even though the court had indicated that that would be the opportunity when he should.
I thank him for his points, but I think I made mine equally as strongly. What consideration was given to allowing conscientious objection by teachers was another question. A large majority of schools in Northern Ireland currently outsource relationship and sexuality education to third-party providers due to the limited professional learning opportunities and teacher confidence to deliver RSE. The matter of whether teachers object to teaching scientifically accurate education on sexual and reproductive health and rights, including access to abortion and contraception, will be a matter for the Department of Education, as they have overall responsibility for education in Northern Ireland. A couple of points were made. A number of points are made around... No, I won't actually, thank you very much. About the Secretary Legislation Scrutiny Committee, and I thank them for their consideration of these regulations. And I'm grateful to have the opportunity to provide further information on these issues. In relation to the coming into force date of the regulations, the Department of Education's position is that it has to follow the direction of the former Education Minister, which meant they are unable to progress the work on this issue. To allow the Department to get on with implementing the CEDAW recommendation, our assessment was that this aspect of the regulations needed to come into force immediately. In addition, Section 12.3 of the Northern Ireland Education Formation Act 2019 has dictated that the instrument should be laid as made affirmative. In relation to the points raised on consultation, the Department advises that significant stakeholder consultation has been undertaken on RSE progression framework, which they've been developing with the curriculum examinations assessment over a number of years, and this is a document we expect to be updated and used as guidance by the department. The consultation with parents on RSE is already common practice in Northern Ireland, and the Department of Education requires each school to have in place its own written policy on how it will address the delivery of RSE. A school's RSE policy should be subject to consultation with parents and endorsed by a school's Board of Governors. These regulations do not change that approach, and we expect and encourage the Department of Education to engage and consult with parents on the guidance they produce and the circumstances in which a parent cannot opt their children out of the specified education. And I talked about the Section 75 and 76 duties I have. On the regulations coming into force, only the duty on the Department of Education to produce guidance came into force on the day the regulations were made. The 21-day convention does not apply to the made affirmative procedure, and so I followed that procedure as dictated by the primary legislation which placed this duty upon me, and I'm very confident in the legal arguments around that. I absolutely believe that the Department for Education should drive forward these implementing, updating the curriculum, as these regulations are designed to do that. And I conclude by saying I had no desire to debate this subject today on a House, but the House made a decision in 2019. That's nearly 4 years ago. This has not been rushed, and I beg to move.
The question is that this committee has considered the Relationships and Sexuality Education Northern Ireland Amendment Regulations 2023. As many of that opinion say aye. Aye. Of the contrary, no.
No. Aye.
Aye. Aye. Division.
Division, no.
Lock the doors.
Sir Robert Buckland.
Aye.
Rob Butler.
Aye.
Chris Elmore.
Aye.
Michael Fabricant.
Aye.
Chris Heaton-Harris.
Aye.
Kate Holland.
Aye.
Peter Kyle.
Aye.
Robert Largan.
Aye.
Jerome Mayhew.
Aye.
Paul Maynard.
Aye.
Jim Shannon.
No.
Kat Smith.
Aye.
Sammy Wilson.
No.
The ayes were 11 and the noes 2.